This is LXBN TV, and I'm Colin O'Keefe. 2013 was a big year for Sarbanes-Oxley and Dodd-Frank whistleblower developments. To look back on the year that was and also discuss what it means for the new year, we bring in attorney Steve Pearlman. He is co-head of Proskauer's Whistleblowing and Retaliation Practice Group, and he is author on the Proskauer Whistleblower Defense blog. Steve, first, let's look back on 2013. What stood out as being among the biggest trends in SOX and Dodd-Frank whistleblower developments? What stood out as being the very biggest development in 2013?
Well, Colin, 2013 was a very big year in the whistleblower and retaliation arena for sure. I think that the biggest event that we saw in 2013, was the $14 million bounty that got issued by the SEC. Many folks became skeptical, wondering, were there going to be gigantic awards? How rigorously would this program be enforced? How effective would this program be? We saw many awards, a handful of awards, hover around $100,000 or so. But by the end of last year, we saw that massive award come down. And we'll talk later, what does that mean? But I think that was the biggest event of the year. It shows that there's a program in place. I think that employers are starting to realize that program is well publicized and very effective, and it's going to make a difference in 2014. We also saw in 2013 the first case ascend to oral argument before the United States Supreme Court. That was in the Lawson versus FMR case, and the question there is whether or not contractor employees are covered by the SOX whistleblower provision. We've seen the First Circuit say that they're not. We've seen the Administrative Review Board say that they are. So this question is going to really be very important to many employers, because we could potentially have scores of new employees having new causes of action under Sarbanes-Oxley. And as we've seen over the years, it's a very powerful cause of action. Another event that was very important in 2013 is we saw a circuit split deepen on the scope of protected activity. In the Wiest decision that came out of the Third Circuit, we saw a very broad interpretation of the scope of protected activity under SOX. But it's important to recognize that determination that the Third Circuit came out with is sharply at odds with the rulings of many other circuit courts, such as the First Circuit and the Ninth Circuit. So this too could potentially ascend up to the United States Supreme Court. We've got a very clear and important circuit split right now. And one other thing that really stood out to me in 2013 was a very pronounced and direct statement that the chief of the Office of the Whistleblower of the SEC made, a statement that he made, which is that he believes that the SEC is empowered to pursue retaliation claims under Dodd-Frank and is apt to do so. And that's very important for employers to take heed, because litigation against the SEC in an employment retaliation claim is going to be very different, and the stakes are going to be arguably higher than litigation against private plaintiffs' attorneys.
I see, and yeah, there are a lot of things that happened in 2013 that have implications for 2014. So let's talk a bit about that. What do you anticipate as being trends on the whistleblower front for the new year? What should employers be aware of?
Well, the first thing that I expect to see are more super-sized bounties, similar to the $14 million bounty that got issued in 2013. I think that we have seen, and if you look on the SEC's website, you'll see this, that there's quite a few cases where things are running up the pipeline. And the program has matured. I think there's more cases that are ripe for bounty awards. The question is going to be, what effect is this going to have on workplace dynamics? Some employers are very concerned that employees are going to continue to bypass internal compliance channels. Instead of going to compliance or HR or legal, they now have an incentive employers would submit to go directly to the SEC. That's troubling for a whole variety of reasons, one of which is that promptitude is so critical when you have a complaint from a whistleblower. And there's delay when somebody goes to an outside agency as opposed to going directly to the company who can turn to its audit committee. The second thing that I see happening in 2014 is that there's going to be an uptick in Dodd-Frank retaliation cases. We've seen a number of very significant cases come out in 2013 and in 2012. I think that we've seen plaintiffs' attorneys have quite a bit of success, although there were some decisions that were quite favorable to the defense bar and to employers. But I think that we're going to continue to see this uptake. We monitor these cases on a daily basis. There's a flurry of cases that have been filed, particularly in the wake of relatively recent employee favorable decisions. And lastly, I'll note that I expect to continue to see a very significant number of impactful Sarbanes-Oxley whistleblower claims, particularly those being filed by high-level executives in 2014. We've seen that the Administrative Review Board has issued a number of rulings that are quite favorable to employees, and we've seen some very large settlements come out of the wake of those decisions. I think that we can only expect 2014 to continue on that trend, but I think we're going to see bigger cases that implicate issues that are more systemic in nature. And I think we're going to see employers needing to respond by putting more resources into their compliance function.
Absolutely. We saw and talked about many big stories in 2013, especially towards the end of 2013. So it does sound like enforcement officials may just be getting started on this front. So it's certainly an area worth keeping an eye on. Once again, that was attorney Steve Pearlman. He is with Proskauer. For more of his insight on whistleblower developments, be sure to visit whistleblowerdefense.com. It's whistleblower-defense.com. And for more of these LXBN TV video interviews, along with curated commentary from the world's largest legal blog network, be sure to visit us at LXBN.com. Thank you for joining me today, Steve.
Thanks so much, Colin.